Status conference docket is Leo Parks, also has number 3.
Good morning, Judge. Mr. Ray Daniel and I have that case, and we are in the process of negotiating some type of resolution for Leo Park. So we've agreed to pass the matter.
Probation, and we were going to put all the probation cases down for today and tomorrow. So is probation here on this case?
We was not anticipating a revocation hearing for Leo Parks this morning, Judge. And even if there were a revocation, and Mr. Daniel could assert to this, but we are in active negotiation to resolve the case by plea.
How long have you been in jail?
He's been confined for over a year, almost over 18 months, Your Honor.
All right.
595 days, Judge.
It'll be on for tomorrow morning. Y'all can either resolve it or we're going to have to hear it on a violation of probation. Not going to keep postponing cases forever because we want to discuss them. We're talking about them. We're waiting on a crime lab report, 1,000 different reasons. We're going to hear these cases. Okay. So tomorrow morning it's on. If y'all can resolve it today, that's great. If you can't, I'll hear it in the morning.
Thank you, Your Honor.
Okay,
Go ahead. We'll be prepared. I'll speak to Mr. Daniel, Your Honor. We'll be prepared to hear the matter tomorrow. And I think that's the only matter I had on the court today, Judge. May I be excused?
Oh, yes, sir. Wait just 1 second. Is probation here with us now?
His probation officer is Mr. Montgomery, and he's been participating in these negotiations as well to resolve this case.
All right, well,
Yes, sir. I'm not his assigned officer, but I'm aware of the situation, sir.
all right, well, for tomorrow morning, we're going to have the hearing. So whoever the assigned officer is, please notify him. Let's move these cases. If y'all can resolve it, that's great. But I'm not just going to let people sit in jail for a year or two anymore. That's just wrong.
Yes, sir.
Number 2 and 4 is Jason Marion.
May I be excused, Your Honor?
Yes, sir. Thank you very much. See you in the morning.
Thank you, Judge.
We've got number 2 and 4 is Jason Marion.
Like it's Mr. Deaver.
Your Honor, that was on for a bond hearing as well.
That's my case, Judge,
Okay.
and not Mr. Weaver's. And there's actually an error on the docket on number 4. That's actually that case number is attached to his underlying charges, which is armed robbery, possession of a firearm by a convicted felon, and possession of a firearm during the commission of a crime.
Okay, this got Mr. Adam Deaver as a lawyer. Have you done an appearance and you're representing him?
We were recently hired, Judge. Yes, sir, we have.
Okay.
And we would like to go forward on the bond hearings this morning.
Well, I'd like
Your
to-
Honor,
on the violation.
if I may, yeah, Your Honor, I'm the assigned probation officer for Mr. Marion. His violation of probation was handled back in November of 2019.
And what happened?
It was revoked 1 year credit for time served.
So has he already served that?
Yes, sir.
He's been in over 2 years, Judge. I agree.
Okay. All right, we'll come, so today you just want a bond hearing
Bond reduction hearing. Yes, sir, please.
on reduction.
Yes, sir.
All right, we'll come back to it in just a few minutes.
Thank you, Judge.
What exactly is the bond hearing on if the VOP has already been handled?
He's got an underlying case.
Miss Henderson, did you say we're going forward on Marion? I'm sorry, I didn't hear you.
Yes, we are.
Yes, ma'am. Thank you.
Is he still on probation? I know we revoked a year of it, but was
No,
that
Your
all?
Honor.
He's not? Okay.
He is still on active probation with us.
Oh, okay.
And he got, so let me understand it. We revoked a year and he got a new charge, or we had pending charges in the year was revoked on the armed robbery charge. What was the chronology, Mr. Probation Officer?
His, I believe, if I remember correctly, this year was vote on some misdemeanors that he had before the armed robbery.
So what's your position on the? Yes, sir.
He was revoked. I think what we're here on is the bond hearing on underlying charges, but he also had these, it was listed under the bond hearing on the motions of status conference. So I don't think there's anything to consider for bond hearings for the VOPs. I think the only thing to consider is for the underlying charges.
Robbery, are you bringing a petition to revoke the remainder of his probation, or what's happening on that?
No, so the petition alleged the armed robbery at the time, but we were not, for some reason or another, the new felonies were not handled. I believe he wanted to go to trial on the new felonies.
Judge, that's correct. This is Anthony Johnson. I actually represented Mr. Jason Marion as it pertains to the VOP. And at the time, he was being held on both the violation of probation as well as the new charges. In order to get it off the court's docket, we went ahead and closed the VOP matter and left only the underlying case open. So there should not be a VOP pending anymore as it pertains to Mr. Marion. It should only be an underlying case.
All right, but the probation officer said he's still on probation, so.
He is. He's
Correct.
The probation officer, all I'm trying to find out, probation officer, are you pursuing anything else on his probation?
No, sir. No.
So instead of violation of probation on the docket, it'll just be armed robbery, bond reduction. What's his bond now?
Currently on the armed robbery, it's $30,000, Judge, and on each firearm charge, it's $10,000. So it's aggregate 50,000. No, it's 60,000. I think he must have three. I'm sorry, the armed robbery is 40,000, Judge. So it's an aggregate of $60,000.
All right,
That's correct.
we'll change it to 58.
We'll wait and be heard on it, Judge. Thank you.
I'd like to be heard.
Yes,
All
sir.
right,
Judge number 5 is Cortez Williams.
Your Honor, Mr. Hocutt and I will be having a blind plea on him in a little while.
Did I have a what on him?
It's a non-negotiated plea today, Judge.
Great.
Number 6 is
That's my case, Your Honor, and we're ready to move forward.
You have to speak up a little bit. Turn your volume up, please.
Can you hear me a little bit better?
Yes, sir.
That's my case, Your Honor, and we're ready to move forward.
And what are we moving forward on?
It's a bond motion and a bond reduction.
For murder?
Yes, sir. I believe theft by receiving he has no bond for, and I believe we were asking for a reduction for the aggravated assault and the murder.
All righty, we'll hear it in a minute.
Number 7 is Brian Crosby.
Your Honor, this is Ms. Morlock with the Public Defender's Office. That is my client. We'll need a brief hearing on the bond issue.
Does he have a bond?
He does not currently have a bond, Your Honor.
Ms. Daly, do you oppose the bond?
Yes, Your Honor. He's on the January trial docket. And so, I mean, we just ask that the court defer until the January trial docket.
You've been in jail all this time without a bond?
No. This happened while he was at MCP. He got it. He beat up, allegedly, assaulted another inmate at MCP. And then after he finished his MCP time that he was serving on a different aggravated assault, we brought him back to our jail to answer for these charges. So he's only been in jail 60 days.
Okay. All right, we'll come back to it then.
Number 8 is Cameron James.
Your Honor, this is Ms. Morlock with the Public Defender's Office. Mr. James is my client. He is also number 17 on the bond and motions docket. We'll need a brief hearing on both of those cases for bond reductions.
Ever heard it before?
Yes, many times.
I believe you have, Your Honor, yes.
I'm not gonna hear it again. Case is off for today. I'm hearing these cases 3 and 4 times for this, the same thing, same bond reductions. So,
Number 9 and 10 are Malik Hightower.
That's my case as well, Your Honor. We're simply asking for a bond to be given and a bond reduction.
ever heard it before?
No, I'm not sure.
Yes, you've heard it before, Judge.
This is Mr. Kendrick's case, Your Honor, so I'm not sure. But the counsel stated.
In Mr. Kendra's case, I probably heard it 4 or 5 times before. But just about every docket, he put somebody down on it.
Yes, Your Honor.
That's probably an exaggeration. So
Yes, Your Honor.
but I've heard it, so I'm gonna take it off.
Already announced on 11. Number 12 is Ronnie McCormick. He also has number 15.
Your Honor, that's going to be a brief bond hearing. He previously had bonds on these charges, but when he was rearrested on new charges, the bonding company came off. I'm just requesting that we set bonds on.
Sorry, Judge, number 12 and 15.
So what happened on number? Yeah, I got it. He's carried, Hightower's carried over to the next page.
Yes, Judge.
All right, gotcha. All right, we'll come back to it.
And number 13 is Kabias Snellings.
Your Honor, that is my client. I'm going to remove the motion for bond today. We're going to be requesting a psychological evaluation.
The DA.
We're opposing any change in bond, Your Honor, because of the case. It should be indicted. If it's not indicted already, it should be indicted in the December grand jury.
I would ask if we don't have a bond reduction that Mr. Daniel, please provide me with the medical records from the victim as soon as possible, even prior to indictment if possible. Could you do that, Mr. Daniel, if we're not getting a reduction?
I'll take a look at the case to see if what we have available, and I'll make whatever I can available.
I think that's the thing that's going to make it take a while to try, is because it's going to all, be turned on the medical records from the victim.
That possibly could be the holdup. So I'll take a closer look at it and I'll advise you, Miss Pardue.
Okay, next case.
Number 16 is Oscar Williams.
Your Honor, we're requesting a reduction for Mr. Williams. His current bonds are $2,500 on the burglary second and $1,000 on each of the forgeries. We're requesting that the forgeries be dropped to $250 each, and possibly if we could drop the burglary slightly as well.
Mr. Hokut.
Judge, if we could just come back to it, we may be able to work something out on it without having to have a hearing.
Okay.
Number 17 is off. Number 18 is Luis Rodriguez Cruz.
Your Honor, my client, Mr. Rodriguez Cruz, does not presently have bonds on any of his charges. He's just a little over 90 days right now. I think his son may be present. His son is the one that intends to bond him out. He's lived in Columbus for quite some time. We'll need a brief hearing on that one.
Okay, who's the DA on that one?
I am, Your Honor. I just picked up the file, so I'll advise during the bond hearing. I'll be ready.
Okay.
Number 19 is Jarquavius McDaniel.
Ms. Daly and I have reached an agreement for bond on this individual. We sent you an order, I think it was yesterday. So we don't need to hear. I can resend it to you if you'd like.
No, you should have it back, but if not, you'll get it back before noon.
Thank you, Your Honor.
Numbers 20 and 21 are Anthony Duffy.
Judge, we're going to withdraw that bond motion.
Okay.
Also, he was also number 22. Number 23, Rashawn Paynes.
We're ready for a bond motion on that, a bond reduction motion on that, Your Honor. You have not heard that before. There are 2 witnesses.
Hey, what number is that one?
Number 23.
23, okay. Why, that's really just, it looks like to me, I don't want to minimize it, but compared to these other charges on the docket, the number 23, Mr. J, Mr. Daniel, false imprisonment, family violence, I mean, what are the bonds now?
It's a
There's no
total,
bond, Your Honor. I think I asked for a total of 25,000 and they didn't go for it.
yeah, it's a total of 35,000 now, Your Honor. Part of the issue is that he does not have any property or anything in order to make this bond, as well as the complaining witness is unwilling to prosecute. So we were asking for a substantial reduction, and unfortunately, we're not able to agree upon it.
Okay. Simple battery, family violence, but I mean, it's serious, but, all right, let's go back to 24.
That's Joshua Statham's.
Sorry, I was muted. We have endeavored to get in touch with Mr. Statham's and his phone has been disconnected. We sent a letter and he has not responded to the letter.
But it sounds like that's something that's on us. If it's a sentence clarification, is that you asking for or what's? who's
No.
asking?
It's actually sentencing. I don't know why it says sentencing clarification on the docket. He pled guilty several months ago. It was pre the pandemic stuff, and it was set down for a sentencing on a docket that I think got canceled. And so we realized recently that he was never sentenced after pleading guilty.
All right, so
Would be
you,
correct, Judge.
so the bench warrants, there a bench warrant outstanding?
No, sir, not yet.
All right, there is now a bench warrant.
Thank you, Judge.
Thank you, Judge.
That's why I
Number-
don't like to have them report later after they plead, because probably won't ever see them again after the end of the plea.
Number 25 is Tanner Martin.
Yes, Judge. I'm not sure how the court wants to handle this. He was originally set for a constitutional speedy trial a couple of months ago, and this court declined to hear it because he was not physically present. We set this for December, hoping that GDC would transport him, and they have not. They did make him available via Zoom. So I don't know if the court wants to go forward with it today.
Prosecution ready?
Defense is ready.
Well, Your Honor, I wasn't sure we could do that by Zoom, but I'll if I need a continuance, I'll go ahead and ask for one, Your Honor.
I got the first part of that, but are y'all opposed?
Your Honor, I wasn't sure if we could do that by Zoom or by internet, but I will go ahead and hear the evidence, and if there's anything we need a continuance for, I'll present that to the court, present that request to the court.
So where is he actually located?
He is in Washington State Prison, Judge. So he's in the.
Well, they wouldn't be doing it by Zoom, would they?
He's in Central State Prison. Judge, we had to ask for some favors, but they did say they could have him here via Zoom.
All right, so do y'all waive his personal appearance? So we
Judge,
can go
I
ahead.
believe if you look on the iPad, that is Mr. Tanner Martin. So he is present via Zoom today.
Right, do you waive his presence in person?
Correct, Your Honor. We physically waive his presence.
Okay. All right, well, I'll be glad to hear it. Y'all ready? We'll get back to it in a few minutes.
26 is Pernell Smith.
Judge, and that is a request for an out-of-time statutory speedy trial. It might somewhat be moot, Judge. I did see the courts, when we filed this was prior to the court sending the January 11th trial docket. And I know that the court wanted to proceed with the individuals that have been incarcerated for a substantial period of time. But we just felt as if we would be one of the cases that would be best suited to be tried earlier.
Well, we have 86 people in jail for murder. I think 33 for aggravated assault. I don't want to use the 1 week we finally get a trial with a jury for not walking on the sidewalk.
Well, I understand that, Judge. I just know that one of the expectations of the that this circuit is to try cases that are somewhat simple, one co-defendant cases that should maybe take a day or two. I do believe that this case actually fits the mold, but I would have to defer to the court. And I know, there's people who've been locked up much longer, so I understand.
And Your Honor, if I may interrupt very briefly, Mr. Smith is actually here. He just came to the office. He's on the 9th floor right now, and I don't know where to tell him to go. So
I apologize, Judge. He was supposed to go to Recorder's Court.
So tell him to go to Recorder's Court?
Well, he can come back to my office. I don't know if the judge is going to hear it anymore, so he can just come back to my office.
I just don't understand why y'all, it's not a serious case. What, y'all haven't been able to work this out?
He was set to plea, Your Honor, at the last hearing date, and at the last minute he backed out.
I honestly don't want to waste a trial week when we got too many other things. People been in jail for a long time. He's out on bond, you said, right?
He is out on bond, Judge. It is complicating the matter. I mean, this is a case that I have been asking to try for at least 9 to 10 months. And
so is everybody else. We haven't tried any cases. We're not, Supreme Court order said we could not try cases.
Well, not even including the pandemic, Judge. This is a case that we have been asking to try, and just the pandemic has exacerbated the issue. But I do understand why this court would want to try those individuals that have been in jail, so I have to defer to the court on that.
Yeah, we got people been in jail 3 and 4 years that we can't let them sit there. Your man's out on bond and you're asking for, he's on the docket for January the 11th. Is that what you said?
He is not on the docket for January 11th.
Not on the docket. Okay. All right. Well, Ms. Clerk, put him on the following docket. He's out on bond, so not January the 11th, but the following docket for trial.
Yes, sir.
Maybe we can work it out between now and then.
Mr. Johnson, you say to send him back to your office?
Yes, he can go back to my office. Come back to my office.
Anybody that shows up on the docket, send them over to Mr. Johnson's office.
I don't know about that, Judge. Go on now. I got limited space, Judge.
Number 27 is Jesse Hardy. We put that down for a status conference because it's on the January 11th trial docket, but that's going to be a null pros. The victim is coming to our office and no longer wants to proceed on the case. So we'll have that up to you today.
Is this person in jail?
He is, Your Honor. He has another case that I'm also going to be resolving today with a plea.
He's been in jail since 2017 on a case that's going to be dismissed?
No, he was in mental health court. He just got kicked out of mental health court about 6 months ago. And then he was returned to jail when he was kicked out of mental health court.
Your Honor, he's going to plead guilty to my case.
And what's that case?
Terroristic threats. It's on an add-on docket, I believe, Judge, for today.
All right. How did he get kicked out of mental health court? I mean, too crazy.
He stopped showing up. They just stopped showing up, Judge.
Okay. All right, terroristic threats. We'll take it in a few minutes.
Number 28 is Kevin Mahone. He's also on the January 11th trial docket, but I believe he was just returned to West Central on a 90-day order because he's incompetent.
Yes, Your Honor. He was also someone who was in mental health court, and we had done a 90-day order a while back, but he had, I believe, absconded from mental health court, but he was back in jail. And I spoke with Sergeant Bowers yesterday, and he has been returned to West Central as of a couple weeks ago.
All right, so he's not going to be tried on January 11th?
No, he's not competent.
He may never be tried.
Yeah, he probably won't be.
And then there's before we get to the VOP docket, there were 2 cases added on. One of them is the Jesse Hardy, Mr. Daniels case, which I believe is going to be a plea.
Yes, Your Honor, that'll be a plea today.
And then there was another one, Ian Godfrey.
And that was it's a bond motion, Your Honor. We were filing for a reduction. He hadn't had a reduction since July. I had filed the motion, but somehow it didn't end up on the docket. So I emailed James yesterday when I noticed it wasn't on the docket.
Have I heard it before?
You did back in July.
Got too much going on today. I'm not going to hear it today. You can,
Okay.
Then the revocation docket number 1 is Harold Hill.
And Your Honor, he's I think we're trying to get that one resolved, but he's out on bond. He is present today at the jail. I want to make sure that he was able to get in because he was having some issues earlier.
Ms. Purdue and Judge, we're in a secure location in the jail behind courtroom number 2. And in courtroom number 2 is traffic court, which happens Tuesdays and Thursdays. So Mr. Hill cannot come back here. He can either do Zoom, or if we were in courtroom 2, he could go to courtroom 2, but they have another court right now.
have you seen him?
Yes, sir. I spoke with him in the lobby, and I told him I'd get back to him as soon as we
'Cause y'all did have another room down there that y'all set up.
We have 2, Judge. One's courtroom 2. That's for traffic court. You got courtroom 1, which is first appearances, and now you have this room, which we use simultaneously for another superior court. But we can't have people off the street in here, only in courtroom number 2.
Can we continue it till tomorrow? Will we have a courtroom available tomorrow? Or would it be better to continue to another date?
Ms. Purdue, are you asking me?
No, I was asking the judge. I think it's a little bit above your pay grade.
I'm deferring it back to the jail. 'Cause are you saying we can hear it, that you can get him in a few minutes?
No, sir, we can't. We have too much traffic back here. We have inmates, unsecured inmates, security inmates. So civilians off the street aren't allowed back here, Judge.
All right, we'll put him down for tomorrow and see if that's the same situation.
Will it be the same situation?
You know what, Ms. Purdue, when I get back to the office, I'll find out for you and call your office, because we did not know traffic court was going on down here. And I guess they're starting back every Tuesdays and Thursdays for traffic court. So I'll find out for you and give you a call.
Okay, because I don't want him to come tomorrow if it's going to be the same situation.
Yes, ma'am.
Thank you.
I'll let you know ASAP.
But Base, I thought even with the 2 courtrooms, y'all had a third location.
This is the third location, Judge. It's a very small room that the judges do not like for mass advisement purposes, but it's a very small area. This is the third location, but nobody can come in here except inmates.
Well, he's technically an inmate.
Well, no, he's not on bond, so that's the issue.
That's as of now. Okay.
Trying to put my people in jail.
All right. That's off to
That's
tomorrow.
Number 2 on the docket is Deborah Kilgore. Ms. Pardue and I have spoken with probation officer on this, and I think we've got it resolved. I think that it can be done via order that the probation officer had sent over to us yesterday.
All right. So is he here in jail, or?
She is in jail, Your Honor.
She is in jail. I don't know that there's any reason to have a hearing necessarily. We're just going to return her to unsupervised probation. We're not going to revoke anything. We're just going to cut her loose, basically. And the probation officer did an order yesterday and emailed it over. Although I don't know if that was emailed to your office or not, Judge.
I've got a stack of them in the box out here that's been signed in the outbox. All right, next case.
Number 3 is Jamal Jones.
I believe we have an agreement on that one, Your Honor.
He's also number 5, just by the way.
Who's the probation officer?
That's me, Your Honor. I'm ready.
Well, they said y'all resolved it.
I believe we have an agreement. We would just need to have an actual hearing. That was it. But everything worked out from my
I can't understand you. I'm sorry.
everything is worked out to my knowledge.
Yeah, we have an agreement. It's going to be 2 years revoked to prison with credit for the time that he served thus far. Correct?
Correct.
Yes.
All right, so who's going to do that order?
I'll have it. I'll fill it out. I'll send it to you, Judge.
All right. So,
Do we need him for the hearing? Are we having a hearing on him?
I
no,
don't
sir.
believe we need a hearing since we have an agreement.
No hearing. Next case.
Or is Anthony Duffy?
Judge, I was going to ask that be continued to December if possible. Me and Mr. Holt could have worked out a couple of things. It's not going to be a full-on hearing, but it is going to be a contested as far as sentencing. And there's a couple of witnesses from tomorrow's hope as well as the family that I'd like to have present.
That's correct, Judge. We've spoken about it. I think it's going to be an admission, and then really, we wanted the witnesses there to be able to discuss a couple of things relative to the VOP, and I don't oppose them having them there.
Or who's the probation officer?
That's also me, Your Honor, and they have informed me that as well. So I'm okay with
It's
it.
your
being passed.
case. It's your case.
Yes, sir. I'm actually scheduled to be in Harris County tomorrow, so I couldn't do it tomorrow, but I'm okay with the continuance for December.
All right.
Hey, Mr. Hocutt, before we conclude, can you go back to position number 14? Scott, what was the position on that?
Got that, that was all for today. Is that correct? That's Ms. Pardue's case.
Okay.
Yes, that's the same announcement as number 3. That's going to be 2 years revoked with credit for time
No.
served.
Let me go back to you mean number 14 on the motions docket.
Correct. Yeah, just Scott. Just
Jakevius Scott.
Oh, yeah, that one was resolved. Ms. Daly and I sent you an order yesterday.
So that's off. You don't need him.
Oh, no, Jakevius Scott, I'm sorry, I was thinking of a different person. Your Honors, I don't think you wanted to hear that when you said you'd already previously heard that one, but I had asked that Ray try to get me the information. So I don't believe we're going to have a hearing on him today.
All right, Mr. Bourne, it's off.
okay. Hey, one more, Mr. Hocutt. 24, Staplemus Joshua.
That one's, y'all have him in jail?
It says no. It's listed as no.
Okay. All right. I'm just making sure. No, that's a bench warrant. Y'all, that's off.
Yes, sir. Okay, that should do it. Thank you. Judge, it looks like we only have one plea. If you want to
Wait, we're not finished.
I may not have a docket, sorry.
All right, how about Jamal Jones? Mr. Probation Officer.
That one's resolved. He has on number 3 and number 5. That's the one that's going to be 2 years revoked with credit for time served.
Correct, Judge. We had previously announced on it because he was on here twice.
Okay, any other cases we missed?
First call Tanner Martin.
It's who?
We did call Tanner Martin. Judge said he's going to hear his case.
Okay.
All right, so which ones do they need to get down for a guilty pleas?
We've got, go ahead.
Cortez Williams, that's a blind plea, position number 5, I believe.
Right. And then also Jesse Hardy.
Hardy, okay. Okay, I'll get them now.
So will y'all be able to get them out at the same time?
Yes, sir. Yes, sir, we will. We can do massive advisement, but we just can't do a big massive advisement. It's like we usually do in the courtroom, Judge. We could probably keep it under, if we had to keep 10 and less maybe, but we just can't do massive advisement like we used to at the government.
Okay, I think we just have 2 today, it looks like. All right, so let's go back to the docket then and start at the top and whatever we have to hear before we take, while they're getting them out.
Yeah, going back to the beginning, Judge, it would be Jason Marion on those armed robbery charges. bond hearing or bond reduction, whatever they've got on that. That's Ms. Henderson and Mr. Daniel.
That's correct, Judge.
All right, you're the moving party, I guess.
Is he out yet?
I want y'all to sit right here.
All right, Base, we also need Jason Marion.
Got you, Judge.
That's not for a plea though. That's just for a bond hearing.
That's just for a bond hearing, so I don't need to bring him out for massive violence.
Oh, they've got our 2 pleas out, Judge.
Yeah, I have our 2 pleas, Judge, right now.
Can I just sit there a moment and let's go ahead and do the bond hearing on Mr. Marion?
We can, Judge.
My name is Mr. Marion. Well, no, don't do those 2 first, it's already in William, and now they want to do the bond here on him.
All right, so are you Mr. Marion?
Yes, sir.
All right, Ms. Henderson.
Thank you, Judge. Yeah, we filed this motion for bond reduction primarily because Mr. Marion has been incarcerated for over 27 months, over 2 years. He'll be 22 in December. He has 1 prior felony, theft by receiving. It's my understanding that the subject of this armed robbery, alleged armed robbery, was a cell phone. And speaking with the witnesses that actually alerted police, there was no weapon. So he's from this area. His mother, his sister, his brother, his grandmother actually lives in Bunker Hill. They're all from this area. He doesn't have a terrible record. He's no threat to any witnesses. Actually, the witnesses were people that he knows and would never harm. And I think based on his record, he's no danger to commit any further crimes. We would just ask for a reasonable bond that the armed robbery would be, cut to at least $20,000, if not more. And then the firearm charges reduced to $2,500.
What about the violation of probation?
It's already been settled, Judge.
All right, Mr. DA.
Your Honor, he currently, Madam Clerk, what is his current bonds?
On the armed robbery, it's $40,000, and on the firearm charges, it's 10.
Okay,
That
thank
is
you.
correct.
Thank you, Ms. Henderson. Your Honor, this is one of several bond hearings we've had on this defendant. For the nature of the charges, I thought that 40,000 was fair. I have no. You said, I'm sorry, you said 40,000 and 10,000?
40,000 on the armed robbery, 10,000 on each firearm charge.
Your Honor, I had proposed reducing it maybe 10,000 total overall, but I don't know if that's agreeable. But with these kind of charges and with
What is
these
his
kind of
total
charges,
bond? How
pardon
many
me,
firearm charges does he have?
he has
How many-
2.
Okay. So
I
he's got
have-
$60,000 in bonds right now, is that right?
Yes, Your Honor.
All right, because of his age, we cut it down to 20,000 on the robbery, 5,000 apiece on the others.
Thank you very much, Judge.
Thank you, Your Honor.
Your Honor, that concludes my business. May I be excused?
Yes, ma'am. Thank you very much.
Thank you, Judge.
Oh, Your Honor, just before that, and the same conditions as before, have the conditions stay the same?
I don't know what
Everything-
the conditions were.
Oh,
He has to cook Thanksgiving turkey. He has to bring in his neighbors.
it's the normal conditions I usually ask for with bond hearings, Your Honor. Those were the conditions that he had before.
The only one that may be a problem will be the ankle bracelet, the curfew, and all the others. There's quite a few requests on there. So let's put all of them except the curfew. I mean, excuse me, except the monitoring, because I'm not sure they're going to build it. He's only 22. He's not gonna
He
have
would
the
not
money.
be able to afford a monitor, Judge.
Your Honor, I didn't get a chance to mention his history before you, but he does have a juvenile record.
Arrest.
But it
As
was
an adult.
as an
That's
adult.
correct, Judge.
As a juvenile, he was a designated felon.
All right, well, that's gonna be the ruling.
Thank you,
If he gets
Judge.
in trouble, we'll put him right back in jail.
Thank you, Your Honor.
But you want to do the,
Name first, what's your names, please?
Hartley. Cortez.
All right, you each have certain rights, and the DA is gonna go over these rights with you. When you enter a plea of guilty, these are the rights you're giving up. So before you can give them up, you have to understand what you're giving up. You have to understand what they are. Just something you do not understand, just let us know. We'll go back over with you. We don't want you pleading guilty and then come back a year from now and say that we railroaded you, we made you plead guilty. You know, we hear that all the time. So we don't, it has to be freely and voluntarily on your part. Nobody can make you plead guilty. So please listen very carefully to your rights. Mr.
yes,
Hooker?
as the judge pointed out, you plead guilty, charged with the crime, you have certain rights, and then when you plead guilty, you're actually giving up those rights. And I'm going to go over attorney. You have the right to speak, to subpoena witnesses and bring out evidence in your favor. You have the right to be represented by an attorney at trial. You cannot afford an attorney. I want appointed for you. You have the right to have the charges against you proved beyond a reasonable doubt. You have the right to remain silent. You cannot be compelled to testify against yourself. Understand that your silence cannot be held against you. You have the right to a direct appeal of a conviction by a higher court within 30 days of the entry of the judgment of conviction. Have the right to an assistance of an attorney during that process. You further represent to the court that you understand that by entering a plea of guilty, you're fully discuss that issue with your attorney. Understand that by pleading guilty to a felony charge, you're giving up the right to possess a firearm. You understand that you're giving up that right even if sentenced under the First Offender Act, that you are not presently under the influence of any mind-altering drug, medication, or alcohol that may affect your ability to understand your rights or enter a plea of guilty, that you're entering the guilty plea freely and voluntarily, fully understand all charges against you and the range of punishments for each charge. You understand that if you wish to withdraw your guilty plea after sentencing, you must file a motion to do so before the end of the term of court in which the sentence was entered. Understand that even if such a motion is timely filed, the court can only grant it to correct a manifest injustice. Understand that by entering a plea of guilty, you will receive a judgment of conviction. You have a right to appeal to a higher court within 30 days of the entry of this judgment of conviction. You have the right to the assistance of an attorney during that process. Understand that any state habeas corpus action must be filed by you or your attorney within 1 year in the case of a misdemeanor conviction or within 4 years in the case of a felony conviction. You affirm to the court that you have been fully discussed these rights with your attorney, had enough time to fully and fairly decide to enter a plea of guilty, and you're fully satisfied with your counsel's representation of you in this case, and that you have read the list of rights and notices that was shown to you by your attorney or had them read to you. You understand that form and your rights completely.
All right, thank you, sir. Mr. Cortez Williams, if you would, the other person can sit down. Mr. Williams, you'll come forward or stand where you are. DA, what are y'all proceeding with on him?
Judge, we're proceeding on 2 misdemeanors, driving while license suspended and obstruction of an officer.
There's the obstruction, just running away.
Yes, Judge, this has to do with it was originally a fleeing case. There's a traffic stop that a Columbus police officer tried to effectuate for a vehicle with no tail light. The vehicle sped off and later crashed, or it stopped in a driveway. The officer saw an individual jump from the driver's side of the vehicle. That person was apprehended outside of an apartment. He claimed that he got out of the driver's side because the passenger side door wouldn't open. The defendant, Mr. Williams, was actually inside the vehicle, inside the apartment. He was hiding in a bathroom, and he was also a passenger in the car. I think the officer originally charged Mr. Williams with the felony fleeing and attempting to elude because he believed him to be the driver. However, after my review of the case, I don't believe that can be proven at trial. And so that's why we're proceeding on the 2 misdemeanors. It is a non-negotiated disposition. State's recommendation is 24 months with 12 months to serve. Credit for time that he's been in.
Purdue?
I'm sorry, Mr. Hogan, you say the state's recommendation is 24 months with 12 months to serve.
That's correct. Or no, excuse me, I'm sorry, it's 24 months to serve. I
That's
just said
right.
your recommendation, my bad.
Look, I'm just gonna go along with that now.
No, I had your email up and I was reading it. I'm sorry. My state's recommendation is 24 months to serve, Judge.
All right, Ms.
And
Purdue.
we had requested that you consider, we're fine with 24 months probation, but we're requesting 12 months to serve, or that you consider that 8 months would be time served.
All right, so is there anything you want to add to what's been said?
Just that my client does not have a felony record, and that we ask that you know, are lenient towards my client. He has a family at home and would like to get home to them.
Is he eligible for first offender?
Because we're proceeding on misdemeanors, he's got other misdemeanors, so there's no reason for him to go under first offender.
All right, Mr. Williams, you want to say anything? Say no. All right, how do you plead to the charge of obstruction of an officer?
Plead guilty.
And your other charge, I'm looking for it here. What's the other charge?
Driving with license suspended.
Driving license suspended. How do you plead to that charge?
Guilty, Your Honor.
Court finds the factual basis for your plea has been free and voluntarily after being advised of your rights. Sends the court to be 8 months, a total of 24 months. After you serve 8, the remainder will be on probation, and you'll be given credit for time served.
Thank you, Your Honor.
Yes, honey.
Okay.
All right, next case.
Your Honor, this is Officer Royal at Georgia Probation Services. If we can have him to report 48 hours after release to 430 First Avenue.
All right, sir. Can you hear that, Mr. Williams?
Yes, on 21st.
I didn't hear what he said.
You want you to repeat the address, I think.
Okay, the address is 430 First Avenue.
You can go back and get it cleared up. I just wanted to make sure that that was clear.
Yes, it's clear.
All right, thanks, sir. That's it for today.
Thank you, Your Honor.
Thank you.
And I believe the other plea is Jesse Hardy.
All right, what you asking?
Civil battery, family violence,
Hardy.
trespass, assault,
All right, Mr. Yeager.
emergency call. He attacked his mom with a pair of scissors. He ended the telephone call. He threatened to kill her, continue his involvement, active involvement that he just dropped out. He has records dating back to 99 where interference with government property, where he damaged some property, forgery, burglary, entering an auto. It looks like his entering an auto. Came in, so that's the reason for being guilty with the simple battery and the criminal trespass and the simple assault. He will be sentenced. We're asking that a sentence for each count be 12 months probation consecutive to the other charges on each count. So that'll make a total of 8 years served, 12 months. No objection. and if it wants to go deviate, the only reason I went up a little higher was because of his record.
Already has terroristic threats, and you're offering 5 years on that, is what you said.
5 years serves 12 months.
Okay.
And I think she's asking for him to, all the other counts to be concurrent.
Yeah, I'm sorry, that was my understanding, but I do see on
Hey,
the
ma'am.
paperwork.
I need to ask you a question. All right, well, okay, that's fine. All right, somebody else, PJ for the week. I'm trying to do other stuff here too. All right, so your client wants to say anything?
He just, asked the court for leniency. I don't believe he wants to say anything.
What's the
we-
draw with Miss Lee? You just keep, is that the issue? He won't stay away from her?
Well, no, we don't want him to stay away from her because he's going to have to be his mother's caretaker. The situation is his brother is
A
currently.
hand on her, you're gonna be right back in jail. You understand that?
Yes, sir.
How do you plead to the charge of terroristic threats
Guilty.
and to simple battery,
Guilty.
criminal trespassing?
Guilty.
All right, there won't be a stay away order because it sounds like you're going back over there. Sends the court to be 5 years. After you serve 12 months, or remain to be on supervised probation. On the simple battery, be 12 months concurrent. On the criminal trespass, 12 months concurrent. Those each be to serve concurrently with count 1. And then you'll be on probation. So you report, as soon as you get out, you report to your probation officer. I did deviate from the sentence. That way you, if you'll stay out of trouble, sir, you won't be on probation that much longer. But you have to go to a mental health program, for anger management. Just do what the probation officer tells you, sir, and you'll be in good shape.
Yes, sir.
Excuse me, Your Honor.
If I may interject, there's another sentence of count 3, criminal trespass, simple assault. We are now processing count 5, hindering emergency contact.
All right, what I've sentenced him on is three charges. You want 4?
Yeah, 4 is the plea agreement, Your Honor.
Yes, Your Honor, that is correct. The only one that was being no pros was the obstruction of a 911 call.
I don't have that on the indictment that y'all sent me. So he's also pleading on interference with a phone call, a 911 emergency
No,
call?
that one was no prost.
I've got him for terroristic threats. He pled guilty. He pled guilty to simple battery, and he pled guilty for criminal trespassing. So is that the charges, or is there another one?
There should be a simple assault charge, I think, Judge.
All right, sir. How do you plead to the simple assault?
Guilty.
12 months to serve concurrent with all the other charges. So you have one 12-month sentence concurrent.
Yeah, I'm gonna go and plug up in the car for a minute.
Excuse me, Your Honor. This is Officer Staten with DCS. What's the name of this? Is this Jesse Hardy?
Right.
Yes, officer.
Okay. All right. Thank you.
Is he on probation with y'all?
No, I'm just trying to prepare the paperwork, necessary
Okay.
paperwork for him once he comes to probation.
Mr. Hardy, are you a resident? If he's in jail on these charges, that's correct.
And the other charge was the burglar was null prost, I believe.
If that's the case, if he's getting released today, then he needs to report to the probation office within 72 hours of his release to 1334 2nd Avenue. And he'll be assigned his officer at that time.
Sir, I'm not saying you're being released today because I don't know. They're going to compute your time. If you've served enough time, and you'll get out. As soon as you get out, you report to probation office.
Yes, sir.
All right, next case.
Thank you, Your Honor.
I know yet. Judge, who would you like next?
Judge, we've got, there's one case on the docket. I don't know. I had one of my victim witness advocates send me a message, number 23, Rashun Payne. We've got a victim in our office on that one. I didn't know if the court wanted to go ahead and do that one.
We're ready if the court wants
I don't
to.
mean.
All right, Rashawn Paynes, Mr. Daniel, that's your case.
Yeah.
This constitutional demand case is probably going to take a little bit longer. Y'all, rather than you sitting here, Mr. Johnson, through the whole docket, you want to put it, I can put it down for like 11 o'clock and you put you in the chat room for a little while.
As long as that's okay for DOT, Judge, that's my only concern. I just want to make sure they'll be available.
All right, number 23 then, Ms. Payne, Ms. Shane Payne. Are you Rasheen Payne?
Yes.
Okay.
Judge, and I'm just going to address the 4 ILO factors very briefly. And so before you, Judge, we have Mr. Rashawn Paynes, and I just want to make the court aware that he has not been incarcerated in 90 days. And the part of the reason of why we have brought him before this court is the sensitivity as far as the time. Mr. Paynes has employment that is somewhat ready for him upon his release. He does have a place of where he can reside. I put my client on notice as well as his family that this court would most likely put on a $35,000 bond. And that is very, very high for this young man. He had just recently moved to Georgia along with his girlfriend, Miss Yoakum, and he just simply does not have the means in order to make that bond. So we were going to ask this court to reduce it from $25,000 on the false imprisonment to $10,000, and then the simple battery, which is a felony, yet the court set it at $5,000. We're going to, I apologize, Judge, that's a misdemeanor, yet the court set it at $2,500. And then the violation of a family violence order, which is at $5,000. And we're going to ask for that to be set at $2,500 as well. And part of the reason of why we're asking that, we do have the alleged victim here. I do believe that she is with the victim advocate, and she has articulated numerous times that she does not in any form or fashion would like to prosecute this case. She has clarified a few things, and I'm not sure if she's going to do that before the court today, but I do know that she is ready, willing, and able to clarify some things for more. She has stated adamantly that she is not in fear for her safety of Mr. Paynes. She would like for him to get out. I know this court may impose a no contact order. I would defer to the court on that. But if needed, he does have another address of where he can reside so that there won't be any issues with either or any allegations between this young man as well as this young lady.
Hi, Mr. DA.
Your Honor, the victim did call me and ask me to drop charges on him. He was recently living in Chicago where he had a felony record in Chicago with gun charges. He's come down, and then pretty soon after he came down here, he got a misdemeanor domestic violence case. And then soon after that, he got another one involving the same lady. And that's when the police came over because they were called. Neighbors heard the victim saying, help me, help me. When they came, they realized that, she said that he was kicking. I think she even had a miscarriage that day, Your Honor. And she tried to characterize it as she was having a miscarriage anyway. I told her I'm not inclined to drop charges or reduce charges because of the circumstances with the most recent domestic violence. But of course, if this court is so inclined to give her a low bond, I'll go ahead and ask for the regular conditions that I usually ask for, including ankle monitoring, curfew, and no contact.
Let me ask you this: if he was, does he have a hold on him for Chicago?
No, Your Honor. He already completed that charge. He was sentenced, and he only had some probation left, and I think that's over with.
Well, from my understanding, Judge, I was under the impression that he was not convicted of any felony or anything along those lines in Chicago. From my understanding, that is his only previous record, and that is a misdemeanor. And I was hesitant to put any medical information as it pertains to this young lady. I do believe that is a sensitive topic, and I do not want to divulge too much into that. But suffice it to say, if a young lady tells me that the reason of why she is in some form of an emotional turmoil and that is because she is having some physical and mental issues as it relates to a miscarriage. I think we should defer to this young lady's statement. I don't think that we could make this linear leap saying that, well, we know her body better than she does. I think that if she says that, I know I'm going to take her at least for her statement.
What are you talking about?
Well, one of the issues, Judge, is that this young lady allegedly had cried for help. And with speaking with her, the reason why she was crying for help is because she was in the midst of having a miscarriage and she needed
Did she come to Georgia with him?
Correct.
All right, so they've been here long enough for her to get a family violence protective order in the past. And now they're saying he's violated that previous order. Is that right, Mr. DA?
And that's the other thing, Judge. She has not sought a family violence protective order. There was a misdemeanor case, and we actually pulled the bond order from the misdemeanor, and there's no contact. There is not a no contact provision whatsoever. From my understanding, she showed up to the court and stated specifically that she would like to have contact, yet the state
for family violence in order.
What she has is that the same victim was involved in 2 family violence cases right after each other, one after another. So it's the same victim on both cases in recent time.
Right, but that's still different than somebody taking out a petition for family violence.
Correct.
You can respond to a domestic case and then make a case, but she didn't really take out he's not a violation of a TPO or a protective order.
He is not.
Is that right, Mr. DA?
That's not the way we're proceeding on the felony, Your Honor.
All right. False imprisonment, $5,000 bond. Ma'am, what is your name, ma'am?
My name is Miss Yoakum, Kayla Yoakum.
You have to speak up.
Kayla Yoakum.
Are you the victim in this case?
Yes.
You know if he gets out, is he gonna come back and stay with you?
I would like him to, but if he's not able to, he would have to go to his dad's house in Atlanta.
Well, I'm not gonna put a stay away order in there, but he has a history. Evidently, he likes to either hit women or wants to be in control. So history shows that it's probably going to happen again, but you're agreeing today for him to come back to you. Is that right?
Yes, please. Knowing
that you could be in danger. Speak up, please, for the court for
Yes, please.
All right. 5,000 on simple false imprisonment, 1,000 apiece on the family violence and the simple battery. Sir, she's not your punching bag. You lay a hand on it again, and I hear about it. I'm going to revoke your bond, put you right back in jail. Do you understand?
Yes.
All right.
Can you get Ronnie McCormick?
Yep. You heard that, Joe? Joe. There you go.
There's Ronnie McCormick's number 12 and number 15 on the motions docket. While they're bringing him out, just procedural history here. He was out on bond on number 12 and number 15 when he picked up 2 new cases. And I believe the bondsman on both of the cases on the docket, when he was arrested on the new cases, came off his bonds.
That is correct.
What are we here for today?
I'm just requesting that we put bonds back on those charges. So if he is able, that he be able to bond out, because he has no bonds on relatively minor charges at this point because of the bonding company.
Why would I give him bonds if he gets out on bond and commits more crimes?
Your Honor, because he doesn't have any bonds right now at all. I mean, they're high. I don't know that he'd be able to get out if he did, but I just like for my clients to have bonds if at all feasible, especially on something this minor.
What are the new charges?
The new charges both, one case is 2 counts. Well, it's a count of financial transaction card theft and a financial transaction card fraud. The other case, which is more serious, is several counts of forgery in the 4th degree, and then a exploitation of an elder person. The concern I have, Judge, is the victim on number 15 on the docket, and one of the new cases, the exploitation of an elder person, is his mother, Blanche McCormick. And I believe that he's been taking advantage and stealing from her. He was out on bond for number 15 and then picked up new charges related to her as the same victim. And so I do have obviously some concerns there. I don't know that Mr. McCormick could make a bond because it appears he's been making his way in the world by stealing from his mother. And I'm hopeful that she doesn't bond him out, obviously. So it may be a moot point, but we would be against bond just because the victims on one of the new cases is the same as what he was already on bond for.
Your Honor, we're requesting bond. It seems to be a family issue going on. I think that my client strongly disputes that he's stealing from his mom. It seems to be an issue among the family. And we're just requesting that a reasonable bond be set on these matters.
So does the victim know about this hearing today?
I believe she would have been notified by our victim witness office, but I don't see her obviously on the Zoom call, Judge. She is in her 80s, Judge. She's 86 years old.
Right, but she could still talk to the victim's witness, and victim's witness could then relay to us the position of the victim.
I'm sorry, Your Honor, what number are you on?
This is Ronnie McCormick, number 12 and number 15.
Tony.
We did notify the victim. The mother is in her 80s. We have also notified the daughter, who has been in touch with them. So they are aware of the hearing.
Are you by yourself?
Yes, sir.
Can you take your mask off?
I'm sorry.
Okay, if you're by yourself, if you're by yourself,
I am now. I'm sorry. Okay. But we have spoken. The victims do know of the hearing that has.
I think it's one of those things, Judge, where I don't think that Ms. McCormick is opposed to a bond. However, given her advanced age, I don't know. I mean, it's one of those deals, Judge, where Mr. Ronnie McCormick's her son, and obviously she doesn't want him in jail, but in speaking
all I'm trying to find out is he going back over there? If he makes bond, does she want him back at the house? If she doesn't, we'll do a stay away order and tell him he can't go back there at all. So does anybody know the answer to that?
We have been told that she is afraid.
All right, so you stay away from that house entirely. You have no reason to go there. You understand?
Yes, sir.
All right. $5,000 on each count. Yes, bonds.
Thank you, Your Honor.
Thank you, Judge.
Who next? Who you want next, Mr. Holcutt?
That's all I have. So.
I do Brian Crosby.
Crosby, yes, ma'am.
Can you give me the number?
That's number 7 on the hearing docket, bond hearing docket.
Play by the numbers. Aggravated assault.
That's correct.
In just a few minutes. We got a message on what is the status of Mr. Martin, Tanner Martin. 25. We're going to hear that in just a few minutes and we'll get to it. It'll probably be around 11. Got so much stuff going on, so we are going to hear it if that's the question. That's your question, Tony? All right, are you Brian Crosby? Is that the one we're dealing with?
Yes, Your Honor.
Okay, proceed.
Thank you, Your Honor. Mr. Crosby is charged in one count of aggravated assault. This assault occurred while he was incarcerated with the Georgia Department of Corrections. It occurred on a trash detail. The alleged victim in the case is also an inmate who was on that trash detail as well. That's one of the reasons he seems to have been in jail for an extended period of time, because this did occur back in 2017 while he was incarcerated. He's actually only been in Muskogee County now for about a little over 60 something days. We have a plea offer on this case that I have discussed with my client. And I need to have some more discussions with him on that. It is on the January 11th trial calendar docket, and the Ms. Daly has given us a time frame of Friday to have a final decision on that plea. In the meantime, though, if granted bond, he would live in Decatur, Georgia with his girlfriend, Kelly McGill, and I have an address I can give off the record for that. I have spoke to her. She's been in constant contact with me the last couple of months regarding his case. So I do know that she does want him to come and reside there with her. He is also still on a 6-year probation sentence for that ag assault that he was serving time for in Department of Corrections. So if he's given a bond, he's not only going to have the bond conditions to make, he's also got to remain in compliance with probation. And we ask that a reasonable bond be set on this until the case can be tried.
Hi, Ms. DA.
Your Honor, at this point, there doesn't seem to be much reason to set a bond. He's only been in our jail 60 days and he's on the trial docket for January. So.
Well, what did he do to this other inmate?
He fractured his skull with a metal jack handle, a metal pole.
That's what the state has alleged, Your Honor.
All right. All right, $10,000 bond on the aggravated assault.
Thank you, Your
He's
Honor.
on the trial docket for January the 11th.
Yes, Your Honor.
What is your offer in the case?
It's a 15 serve 4, and the credit would just be for the time that he's been in jail, which is like 50 some, almost 60 days.
All right, sir. Is that your understanding of the agreement, sir?
Yes, I understand.
All right. Well, that's your offer. You won the trial January 11th. You can either accept that or go to trial. It's your choice. All right, or you can plead cold. You always can plead guilty whenever you want to. Or he's offered today then, right?
Yes, with that $10,000 bond you just set, Your Honor. I'll prepare
Right.
an order. Thank you.
And we have the next one, number 6, Dondra Hill.
Not very good. Not very, whatever it is.
So who represents Mr. Hill?
That's my case, Your Honor.
Now, are you sitting in for Mr. Kendrick or are you going to be representing him?
I'm sitting in for Mr. Kendrick.
Didn't y'all say I've heard this before?
I know, sir. That was my number 7. That was Mr. Hightower.
Is my time up?
Yes, so you have heard it before when Ms. Pardue represented him
All right,
Is that
start with
correct?
murder, aggravated assault. What is your request now? Is it, does he have bonds?
He has bonds on everything except for his theft by receiving, Your Honor.
All right, $2,500 on theft by receiving.
For the murder,
I'm not gonna change the others. I'm not gonna change the others.
Thank you, Judge.
Okay, he has bonds on everything now. Tell Mr. Kim to do not put it back on the docket for a fourth time.
Well, this is no, Your Honor, this is a new case of ours. This is our first time having it on the docket, Your Honor.
Well, I know, but if Ms. Purdue had it or two other lawyers and everybody comes just wanting a bond reduction, what's his bond on murder now? What's his bond on murder?
$50,000 bond, Your Honor.
Well, I'm not gonna go any lower than that on a charge of murder.
Your Honor, respectfully, we're just trying to advocate for our client, Your Honor.
I understand. I'm not trying to kill the messenger. I got so many cases, I'm hearing the same ones over and over again.
I understand, Your Honor, and I appreciate you setting the bond for the theft by receiving for $2,500, Your Honor.
Yes, sir.
Thank you, Your Honor. That's all I have. May I be excused, please?
Yes, sir. I know you'd be glad. All right, who's next?
Tanner Martin next.
I think the judge said we're going to hear Tanner Martin at 11 o'clock.
11 o'clock.
Yep. Can DLC accommodate that?
We have one more before Mr. Martin.
Oh, all right. It actually might be before 11 then.
I think Luis Rodriguez. Did we do that, Ms. Pardue?
We have not. We need to set, he doesn't have any bonds.
Okay. Luis Rodriguez.
What was that, Tony?
Luis Rodriguez Cruz. I believe his son may also be on the Zoom call. Mr. Rodriguez Cruz, the son, are you on the Zoom call? Okay. Your Honor, this is Mr. Luis Rodriguez Cruz. He is a U.S. citizen. He's from Puerto Rico. I will be speaking for him because his primary language is Spanish. He's charged with 10 counts of pornography. It was, I believe, a search incident to a search warrant on a computer within the home was where it was found. And we're just requesting that we put bond on each of his charges. He lives here locally, has lived here locally for many years, and we're just requesting a reasonable bond. His son, I thought his son was going to be on the call because I'd spoken with his son several times, but and my client has no prior record, and he would be living at 3140 Urban Avenue.
Now, is the pornography involving a family member at that address?
No, it is not. It is not. It was just random internet pornography is what is alleged. And my client is presently employed at Alitrade in Phoenix City and has been for quite some time. He typically works 7 a.m. until 4:30. So we're requesting that if they do put a curfew, that we take into account his work schedule and that he works in Phoenix City.
All right, Mr. DA.
Yeah, first of all, I just don't
know today. And because Spanish is his primary language, we had talked about possibly doing a translator, but with a Zoom call, I felt it would be best not to. And I told him I'd explain everything before and after. And I explained to him exactly what would happen today.
Mr. Rodriguez, how old are you?
¿Cuántos años tiene?
Mr. Rodriguez, how old are you?
54.
Okay, so you understood that, right? You do understand some English. How long you been here?
I've been, you gotta speak up.
How long have you been in the United States?
I've been
10 years?
20-something.
20-something years.
Well, I'm sure he knows how to speak English then.
Yeah, he's been here for quite some time, and you know, I know he knows some English, but I also have explained to him everything that's going to transpire here and told him I'd explain everything afterwards in Spanish.
$5,000 bond on each count.
Thank you, Your Honor.
Come on.
There'll be conditions, Mr. DA, the conditions, of course. I won't do the ankle bracelets, but he does need to have the other conditions, including no access to computers and all that. Same terms we've always been putting these things.
If there's a curfew, could we make it so that he would be able to leave
Yes.
the house by 6 a.m. and not return till, 6 p.m. because he does work long hours typically.
But just put other than work is in the order.
Okay. All right, and Ray, if you'll get that to me, we'll get it signed and sent over.
Sure, I'll work on that right now, right after today's hearing.
All right, thank you.
Your Honor, the only thing that I have left is Martin Tanner. Is there anyone else that has another case before that?
What number is Montana?
Martin Tanner.
That's 25, Judge.
25, thank you.
Montana. Bailey,
Does that mean there are no other violation of probations? There are no other pleas? This is the only thing left?
I told her to keep him down because I don't know the position. Mr. Daniels or Miss Pardue, did either of y'all have an Oscar Williams? I didn't get the position on that one.
I didn't. Mine. Me and Mr. Hocutt have come to an agreement on bonds.
Okay, thank you.
This is Officer Staten. Did you get that message that I sent you?
Yeah, I actually
Hardy?
direct messaged you Mr. Hardy's information.
Okay, thank you.
Thank you.
Only one that we have left is Tanner Martin, is that it?
Yes, that's correct. Understanding, Your Honor.
All right.
And you guys don't have Tanner in custody.
Correct. No, Tanner's outside the jail on Zoom. Mr.
Okay, we don't see their feed. Yes, sir. Yes, Base.
No, sir, I'm fine. I was just making sure Tanner was our last one. Tanner Martin was our last one.
So y'all are finished for the day, and victims witness. Do y'all have anybody on the Martin Tanner case or Tanner Martin case? No, you're muted. So
I'm sorry, I haven't seen anyone. We did have somebody that we sent the link to, but I don't see that they are logged in.
all right. Well, we've got a lot of people logged in here. That are they on other cases, or all these people on this case, or?
Judge, may we be excused?
Yes, sir. Thank you very much, sir.
Thank you.
See you in the morning. All right. Well, still got a lot of people online here. Is this the only cases left? Speak up if anybody else is online here. Are you here on another case other than Tanner Martin? All right, let's proceed.
All right, Judge. Before you, we have Mr. Tanner Martin, and I'm not going to belabor the court too long. I will be somewhat brief, but he is before this court on SU 17 CR 2374. This would actually, had Mr. Martin been in the custody of Muskogee County Jail, I believe that this case would be the oldest case, or one of the oldest cases that would be on this court's docket. I know that he would at least have been T1, if not T3, on the January 11th docket. This offense was alleged to have occurred in July 13th of 2016. He was indicted in August 15 of 2017 and arraigned on that same day. And I'm just going to briefly highlight some of the four.
All right, do this, Mr. Johnson, so the transcript will be in a chronology order here.
Okay.
Exactly what is your motion? There are different ways to frame this particular question. So how are you asking this to be dealt with?
This is a motion to dismiss for lack of constitutional speedy trial.
All right, sir, go ahead.
And what aspect, Your Honor? I guess I'm trying to find out what aspect of constitutional speedy trial is he saying he was violated?
Well, Judge, we're going to go over the 4 Barker v. Wingo factors.
All right, but where's he been since 2016?
He has been, for the majority of that, he has been in the custody of control of the Department of Corrections. He has been in
other charges?
On a probation violation in a different county, Your Honor.
All right, go ahead.
Judge, and just to highlight one of the first 4 factors in the Barker v. Wingo is the length of delay. I think that we would all concede that it is presumptively prejudicial. It is well in excess of the year. So I don't want to spend too much time on that, Judge, but I do want to make the court aware that it has been 4 years, almost 5 years since Mr. Martin has been brought before this court. Even if we exclude the time frame where the court issued a judicial emergency, we're still talking about almost 3.5 years in which Mr. Martin has not been brought to trial. So our standpoint is not only is it presumptively prejudicial, it is an uncommonly long delay which weighs substantially against the state. And then we get to Judge.
Mr. Johnson, has he been indicted?
He has been indicted. He was indicted on August 15th of 2017.
All right, so the state, y'all knew where he was, you just didn't bring him back? Because I'm going to deal with his first prong. Mr. DA?
Yeah, no, he had bench warrants on him, and he was outside the state's purview, Your Honor. So this is, first of all, he was indicted. I'll let Mr. Johnson say his whole argument, but it's really moot because of his incarceration elsewhere, and he's not demanded. This is not the vehicle that would be appropriate in these challenges.
Well, Judge, this is why I think that this motion is going to be somewhat brief, because we have argued some of this before, and that was one of the issues in which Mr. Daniels brought up. Unfortunately, the Court of Appeals disagrees with Mr. Daniels. One of the issues that we heard is that Mr. was the reason for delay. There was an assertion made that Mr. Martin should, in some form or fashion, made some request to be brought back before this court. I would, if he were in a different jurisdiction, if he was in federal custody or in Alabama, I would agree with that. But if he is in the custody of Georgia, which he has been, I think we can rely on Johnson v. State and Hester v. State. I can give the citations if this court's want, but suffice it to say,
give those to Siobhan Thomas. That'd be his first case of his new career.
Okay. So Johnson v. State is 749 Southeast 2D 828, and Hester v. State is 268 GA App 97. And suffice it to say, Judge, that both cases in conjunction state that it is not the burden of the defendant to be brought to trial. It is the state's burden to bring defendants to trial. They have the responsibility of proving beyond a reasonable doubt, which means that they have to get their witnesses. They have, especially when the defendant is in the custody and control, they have the burden of bringing the case to trial.
Getting redundant now. Let's move on to the next prong.
Well, Judge, I'm hoping you agree with me.
I agree that 1 year is prejudicial and you reach the threshold. Now let's show me it's intentional on behalf of the state.
Well, it doesn't have to be intentional, Judge. It can be through negligence. And I think, I think that's kind of the crux of the issue is that, and we'll break away from the factors, is that the Court of Appeals has said that you can't just give a person a DOC sentence and then pretend like the case doesn't exist. The time still continues. The expectation is still that a person has to be brought to trial. And I'm going to go down to the defendant's assertion of rights, Judge. I think that this is the only prong in which it doesn't really necessarily weigh either for or against us, in that he asserted his constitutional speedy trial when we hired, and that's been almost a year ago. And of course, we still haven't been able to hear that because of, in part, what we're doing with COVID. And then I want to go down to the prejudice to the defendant.
So where has he been in jail?
He's been in prison.
All right, where's he been in prison?
In Central State Prison
And where's that at?
in Macon, Georgia.
Because the DA was saying he's been in another jurisdiction. Was he in prison someplace else?
He has never been anywhere other than the state of Georgia as far as prison.
Okay.
Yeah,
Is that right, Mr.?
Yeah, I didn't mean, I never said that he's been in another jurisdiction. I just said that he's been incarcerated and we don't have him here. So he's been incarcerated. We didn't know where he was. It was a bench warrant outstanding and he was already indicted. So we were ready to go. We've done everything in our power to get this case moving until I guess sometime this year is when he first asserted his rights for speedy trial. So, Your Honor, that I think that speaks for itself that this is not a violation of his constitutional rights to a speedy trial.
All right, go ahead, Mr. Johnson.
Well, Judge, and when it comes to the prejudice to the defendant, one of the things that is looked at is the oppressive pretrial incarceration and minimizing anxiety and concern. One of the issues that Mr. Tanner has before him is that he is per se ineligible for parole as long as he has this pending hold from Muskogee County. And so what the state did by issuing a bench warrant is to effectively say that he's effectively going to have to serve 2 more additional years on his sentence because the state decided to issue this bench warrant and put this hold against him. So that's how one of the ways that he has been one of the ways that he has been prejudiced. And that's
let me ask you this now, Mr. Johnson, so we'll be on the record correctly.
Okay.
Are you saying that he has been eligible during this time? He's been eligible for parole and would have gotten out except for this bench warrant?
Correct. He is not. And from my understanding, that's the policy of the Department of Corrections, is that when an individual has a hold from a different jurisdiction, they cannot be considered for parole. So he has been eligible for parole, I want to say, since almost the beginning of this year.
Do you have anything in writing to that effect?
I do not. I'm sure my client would tell you that, though.
Well, I mean, somebody just can't say it. It's just like saying, they told me I was going to get out a month after I was sentenced. I never did. So, I mean, you got to have some kind of proof he was eligible for parole, and because of this case, he couldn't get out. Can't just say it.
Well, okay, Judge. I mean, if the court wants us to produce something along those lines, I will contact the Department of Corrections. I think I can get that information to the court.
Okay, because I know you're just going by what he's telling you, and so it may be true, but you got to be able to prove. But go ahead and let me hear the rest of your argument.
And
were there any witnesses? Have any witnesses died, or it's got to be prejudicial to a trial too? He couldn't have the same evidence because of the timeline.
Well, correct. So the evidence exchange, I have tried to reach out to the witnesses, and I have been unavailable to and this is somewhat attenuated, Judge, but this case involves children. These children have grown. Some of them are double in age, so they don't recall their aspect of it. And then the alleged victim itself, which is a young man, I haven't been able to reach him, but through members of his friends, they have stated that he does not want to prosecute, but we cannot verify that. So we've been prejudiced because we haven't been able to communicate with this individual to further investigate the case. But, and that's all that we have, Judge, as it pertains to the Barker v. Wingo factors in the constitutional speedy trial.
Did you say you had talked to the family member and they didn't remember this? Is that what you said?
So there are 2 aspects of that. There are minor children that are involved, and now some of them have doubled in age. They were 4 and 5 at the time, so their ability to recall what has happened has diminished. And then there's also the alleged victim, and he was a young man, and we have tried to contact him, but his family members have articulated, well, his family and friends, because this does share a domestic aspect of things, Judge, and they have articulated that he has expressed to them that he does not want to prosecute, but we have not been able to verify that.
That wouldn't even be admissible to say some friend of his said the victim don't want to testify.
Well, exactly, and that speaks to the impairment. So we would need to be able to contact this individual in order to investigate and say, hey, look, this is their standpoint. And I don't know if the state has that information. I mean, this is my first time hearing that someone was available, but we have tried to endeavor into tracking this young man down, and he has been nowhere to be found for us.
All right, Mr. DA, what you want to say in response?
Well, Your Honor, he's been incarcerated. There's a bench warrant out on him. None of that time is when he's out in the wind and we don't know where he is. And then he turns up that he's incarcerated elsewhere. All of that time is not accounted to us. We don't know where he is. And then the first time they even tell us that he wants a speedy trial is within the year during this COVID time. So, Your Honor, and there's no indication that there's any prosecutorial wrongdoing. I didn't do anything wrong to try to hold him back or hold back evidence so that it helps my case. So none of the factors have been satisfied in my view.
So do you know where the victim is?
Are you asking me, Your Honor?
Yes, sir.
I'm going to, what we would do is that we knew where the victim was at the time. This was before the bench warrants. So if this is, he's ready to go, and I don't think this is appropriate for the first trial or two under the new pandemic system, but soon thereafter, we would just get this case ready for trial, and we'll deal with it if the court is agreeable.
Well, he makes it sound like there's several children involved,
Yeah, and I really, as far as cruelty to children kind of cases, children witnesses, I'm very cautious on talking to them and getting them ready for trial. That's very strategically done by me, because I don't want them to get.
What I'm asking you, are there several children involved in the case?
Oh, I just have one charge, Your Honor.
One child.
One charge of cruelty to children.
Cruelty to children sounds like.
Into 2017.
All right, were y'all given a copy of the indictment and a list of witnesses?
The state has not provided us with any of that, Your Honor.
Even at the arraignment?
We weren't his counsel of record as far as the arraignment, Judge. But since we have entered, we have not received any of that.
All right.
But if this court is inclined to, if this court is going to hold against us, I think this is a case of which we could get up to speed rather quickly.
I think he went to get the file. All right, man, you want to come up? I got something else I have to do, y'all, so just hang on a second. This is in reference to to do what? She has this. Well, when is it here? Then the judge just
Get out now,
signed it.
Your Honor.
No, this one. This was taken to the side.
Well, normally they would take it to a grand jury and find him for violation of, if it turns into a felony after he's under, if there's an order issued. This is just the petition, right? So is there an order been issued? Okay, you're saying that. There it is. Tell him to take it to the DA's office. I'm sorry, Ray, go ahead.
Yes, Your Honor. I only have one victim.
All right, so he's saying the victim is grown and they don't know where the victim is or hadn't been able to contact the victim. At the arraignment, did y'all give whoever represented him at that time a copy of the indictment and a list of the witnesses?
Your Honor, that's our normal practice. I could find the receipt that we usually have in the actual file, but it's in the bench warrant drawer right now. But that's our normal practice, and he should have gotten it from the previous attorney.
Right, but can you go ahead and send them?
Of course. I'll go ahead under the circumstances, Your Honor, and prepare a discovery for them on this case as the same thing we gave to the previous attorney.
Well, Judge, I think that, and this is why I can't seem to highlight the importance of the timing. The information that they're going to give us is most likely going to be out of date. If they're going to give me the same number that the other witnesses have given me, it doesn't work. That's the issue, is that I'm getting a 4-year-old number.
He ain't got no cell phone.
Mr. Martin.
Yeah, he can only give you what, they got to produce the person for court. I'm not going to rule against you. I'm going to put it in abeyance until we go ahead and put it down for trial, not January the 11th, but the following trial date. Trying to get a murder ready for the 11th.
Is he going to get an order, prepare order to be brought, Your Honor? Because that's the defense. That's what the defense usually do.
I want to continue until we see if you comply with the witnesses, the list of witnesses, the address, information on the victim, so we can go ahead and proceed to trial.
Oh, I'm going to try to send that today, Your Honor.
Okay. Then the next thing I hear is that we're ready for trial. So right now.
But I just want to make sure they do the order that we get him back from wherever he is and get him here for the trial, and I'll be ready.
Well, he's online. Where's your client located?
He's located in Central State. Judge, we will have an order of production for Mr. Martin done, completed at the court's convenience, and we will be ready for, we'll take T1 on. If the court wants to do that in February, we're perfectly fine with that.
Right, February. I'm not going to say T1, he'd be on the trial docket for February.
And Judge, would this court have any objection, just to, I guess, further perfect the record? I would like to submit to the court at a later date, some of the substantiating documents in regards to what I have just previously discussed, just to perfect the record.
I want to see them.
Anthony.
Ms. Lopez. Yes, ma'am.
Judge Peters did not hear you because his computer's rebooting. Please repeat what you said.
To perfect the record, Judge, I just want to make sure the court didn't have any objection with me submitting some substantiating documents along the lines of the parole and having outstanding holds from counties. And I will allow.
Left this open, this hearing open for you to apply from the Board of Corrections about the parole, and also for them to comply with the arraignment and the list of witnesses and information for court for trial. So we'll see how that goes. I'm not going to rule on it for 60 days to give everybody time to get the record perfected.
Okay. I think I heard that, Ms. Lopez. It was the arraignment, the parole.
My computer went off.
Anthony, repeat yourself, please.
I said, I think I heard most of it. Judge is not going to rule on it for 60 days. He wanted the information from an arraignment, the parole, and what was that other thing?
Just whatever y'all want to amend the record with.
Okay.
Whatever you want to amend the record with.
Okay, sounds good to me.
All right, then.